Ladies and gentlemen, good day and welcome to our webinar, Arbitration and Conciliation, Amendment Act 2019, Age of Orwellian Arbitration. As a reminder, all participant lines will be in the listen-only mode, and there will be an opportunity for you to ask questions after the presentation concludes. Should you need assistance during the conference, please signal an operator by pressing star then 0 on your touchtone phone. Please note that this conference is being recorded. I now hand the conference over to Mr. Ashish Kabra. Thank you, and over to you, sir.
Thank you. Firstly, a very warm welcome to all the participants who have taken the time out today and joined in on this webinar titled the Arbitration Conciliation Amendment Act 2019, the Age of Orwellian Arbitration. We are very grateful that joining us today is one of the world's foremost silk on the subject, Mr. Toby Landau. Toby is a barrister and arbitrator, and he has acted as the lead counsel in several landmark cases where the judicial decisions have gained international significance. So Toby, thank you for joining us today, and we look forward to hearing your views in the course of this webinar. Much appreciated. Along with Toby, we have today Mr. Nishith Desai. He heads the practice here at Nishith Desai Associates, the disputes practice. And along with Nishith, we have a very capable member of our team, Ms. Bhavna Sundar. And finally, myself, Ashish, I lead the disputes practice of the firm here in Singapore. Now, before we delve into the webinar, 2 points of order. First, sort of keeping in sync with our firm's international approach and outlook, speakers today are joining in from different places. Vyapak and Bhavna join in from Mumbai, while Toby is currently based in our Delhi office, and I'm joining from the Singapore office of the firm. So please do bear with us that in case there is any overlap, while we will do our best to avoid any such thing happening. And secondly, the structure of the webinar today is obviously focusing on trying to get Toby's perspective, or rather international perspective, on these changes which have now been introduced. We'll keep it brief, and hopefully soon we'll be able to open the lines for questions from the participants, and thereafter sort of move forward further to any other changes if time permits, to discuss any other changes which have been made through this amendment in the Act. Now, sort of starting with the subject, our webinar today is on the Arbitration Conciliation Amendment Act, which has introduced several key changes in the Indian arbitration regime. Sort of connected with our title is the first key change, which is the introduction of Arbitration Council of India. Now, these amendments were based on the report of a high-level committee, which proposed introduction of such a council, or rather it had proposed introduction of an Arbitration Promotion Council of India, which has now been introduced in form of Arbitration Council of India. Different from what the committee recommended, the Arbitration Council will basically have a governing body which comprises of members of the different ministries in the government, and other members which are basically appointed by the central government. The role of this Arbitration Council is essentially to grade arbitral institutions, intent being that this grading may lead to improvement in the standards of these institutions, and other functions such as reviewing the accreditation of the arbitrators and trying to see if institutional arbitration can be promoted in India. However, obviously, there is no equivalent body which we have seen in other parts of, or in any other arbitration-friendly jurisdiction internationally. And on this, I would like to bring in Toby to understand his views and what does he feel about such a body being introduced in India, and what is the international outlook towards this proposal or this body called Arbitration Council of India.
Thank you very much, and a welcome to everyone who's part of this. So I think the starting point in analysing this new animal, the Arbitration Council of India, is to acknowledge why, as far as I've understood, it's been promulgated, why it's been put in place. There is certainly a concern, and I can see a concern with more force in India about having benchmarks and quality control for arbitral institutions, given the fundamental role, the central role that institutions play, and the fact that they are generally self-regulating and unsupervised. And there are genuine concerns in different parts of the world about how good they are and how well they operate. So the starting point, I think, is one can see the genesis of it, why it's come about. The end result, to be frank, from a foreign perspective, is deeply troubling. What we have is, as you already mentioned, something which is unique. There is no such body in any other modern arbitration jurisdiction. And so its nature, its composition, and its functions are as yet unclear because there's no precedent. Now, if you look at the law as it's been passed, there are a number of troubling aspects to it, in my view. And a lot of these, when one goes through them, one has to test from the point of view of perceptions, not just what might or might not turn out in fact, because perceptions are vital for the health and future of any arbitration system. If people perceive that this could be problematic, then they will move away from that particular jurisdiction. In terms of itemizing what the concerns are, firstly, the constitution of the council itself. The council looks like it will be populated by nominees of central government, or there will be a central government critical role in its constitution. That immediately raises questions of neutrality. It raises issues of experience and expertise. It raises issues of a lack of international perspective. It starts to look like a government agency, even if that wasn't what was intended, and certainly in terms of perception. My belief is that it will be seen as that. We do have precedents around the world of how dangerous government interference or control of arbitration can be. To give you one example, when the Arbitration Centre of Thailand was constituted, it was set up as an autonomous body originally, but it was housed within the Thai Ministry of Justice. So its address was the same as the government ministry, and it was staffed by civil servants who were also working at the Ministry of Justice. And that was a major problem in its development, simply because people thought it's not independent, it's not neutral. That has an immediate impact on cases obviously involving the government, cases where there's any relationship to the government, but it might also have an issue with respect to any case where the government has its own view or has its own concern. So the constitution is the first point, which I think is a major concern. The second point is it's unclear actually what this council will do. What's the full extent of its powers? What kind of grading will take place? And what will the process be in order to arrive at a grade? Will it actually be intervening? Will it be guiding institutions as to how they should discharge their functions? And if there's any hint of that, then institutions become dependent upon it or beholden to it. Perhaps they become beholden to it in order to maintain their grading. And at that point, that will do serious damage to the autonomy, independence of institutions, and it will be perceived as simply another encroachment by the state on the arbitral system itself. So I think that's the second major concern. The third concern is that, and this is a concern which I think permeates many of the points that we will cover in the new law. The third concern is that whenever you impose more regulation of this sort, you open up more opportunities for satellite litigation. That is, people who will challenge whether or not the detail of the law has been properly complied with. If you've got a grading system by a council, you would then open up the possibility of challenges to that grading process. or challenges to an institution because it hasn't fully complied or may not have complied in some way with its supervisory structure. And so that is another concern, that actually everything simply becomes more complex. So just to finish off on this, I think if this is going to work, coming back to where I started, because there's a need, perhaps in India, of quality control and benchmarking, it is imperative that the precise ambit of the powers of the council are absolutely clear, that there's no ambiguity, and it's imperative that its constitution is made acceptable for an international audience. And that means it mustn't be central government controlled at all, and it must be international.
Thank you. It's interesting to know and sort of see the international perspective, and that there is skepticism around the aspect of government influence coming in, and obviously interesting to hear the Thai example. This sort of moving on to the second key change which is there, and I'll probably bring Vyapak in on this first. That is the introduction of the 8th schedule, which provides for qualifications and norms which are required for a person to act as an arbitrator in an India-seated arbitration. These amendments essentially introduce a section which is 43J into the Arbitration Act, and the section then connects with the 8th schedule, which lists down certain qualifications and norms. Vyapak, what are your thoughts on whether provision of such qualification and norms, and also considering the nature of those qualifications and norms which are actually being prescribed? What are your views if this is a positive step, negative step, and then probably you can leave the discussion towards Toby on this point.
Sure. So I think in India, everything is based on some, basic requirement or some thought, which is, in my view, usually pretty much good and good faith basis in that sense. I think as we heard Toby on the arbitration council, even the need for a better pool of arbitrators as a thought or as a basic requirement is a concept which nobody can deny. So I don't think as a starting point there is anything wrong. The problem with Indian laws and the amendments and the way they are written is the skepticism comes on the mischief that it can play in terms of its implementation or in terms of affecting rights and interests of parties in general. So like the Arbitration Council of India, as we saw, the committee report talked about Arbitration Promotion Council of India, and the main change that they did was do away with the word promotion. And I don't know what's the objective of doing that. Similarly, as part of this 8th schedule which they have introduced, if you see the section 43J, they are talk about the qualification, experience, and accreditation of arbitrators. Now, they are bringing in this as part of three very different concepts: qualification, experience, and accreditation. And then, if you go to the 8th schedule, it talks a little different, because the opening statement itself says a person shall not be qualified to be an arbitrator unless he is, and then it goes into every aspect of the qualification. So I think the mischief here can be that at one end you are talking about grading of institutions, now you are talking about in a way grading of arbitrators, and then you are talking about disqualification of an arbitrator and laying down principles on which that disqualification can take place. And then there are items in that disqualification, such as you need to be an advocate in India, which otherwise would require you need to be an Indian citizen. Then it would say you need to know basic principles of constitution law of India, and so on and so forth. Now, question is, when you talk about arbitration in India or internationally, I think the only principle which flows across is party autonomy, and the right to choose your own arbitrator. I think, in my view, those are the paramount items as far as the arbitration goes, because that's the basic construct as to why you move out of litigation. That you get much more autonomy and even a right to choose who would adjudicate your disputes. Here you are talking about qualifications and then grading. Uh, uh, One is the issues on domestic side, but considering today's webinar, we want to focus more on the international perspective, with Toby being part of this. Is uh, Will this raise a doubt in the mind of foreign parties? Let's say, to say, can they even appoint a foreign practitioner, or let's say appoint Toby as an arbitrator in an India seated arbitration? Uh, do you want to even give that doubt in anybody's mind by putting such provisions? One can interpret this in many different ways, but any perception to even suggest would lead a negative impact on the arbitration in India rather than a positive one. What possibly is required as part of the law is to increase the pool of arbitrators. Yes, there are institutions who train arbitrators, there are institutions who do the courses, integrate them as part of the arbitration community in India, or look at some other provisions. But to bring about a law and a statutory qualifications, in my view, is uh, not required at this stage, when we are anyways grappling with many other issues in India.
Thank you. And it's interesting because the norms which are also listed in the 8th schedule are in that sense amusing, because it says an arbitrator shall be conversant with the Constitution of India and so on. Now I do know Toby is licensed to practice in several jurisdictions, Singapore, England included, but probably it may be difficult for Toby to get accredited as an arbitrator in India given the prescription of these norms. Toby, what are your thoughts on this introduction of 8th schedule by way of the amendments?
So, putting out of my mind the fact that I am now disqualified to sit in arbitration in India, which I'm trying to be not affected by that in my answer to you. I agree with everything that's been said so far about the problems with this. I'll highlight two particular points from a foreigner's perspective. The first point is the obvious one that's already been mentioned, that it's so unclear. It looks like if the intention is to exclude people who are not qualified in India or know the Constitution well. And if that's right, then that is a serious blow to international arbitration in India. There is, I can't see any justification for that. It undermines party autonomy, and it is a huge warning for people not to come to India to seek their arbitrations for international matters, if in fact the pool of arbitrators, potential arbitrators, has now been restricted to only Indian qualified. The second point is to recognize that, again, I can understand what's been motivating this in terms of quality control. But many other countries considered such a provision in their arbitration law and decided not to include it. England is one example. When the 1996 Act in England was drafted, we had a debate about putting in requirements or qualifications for arbitrators, and a firm decision was taken not to do it. And that is a shared principle amongst most arbitration laws around the world. One of the key reasons for that is not just about party autonomy. It's also about the problem, again, of generating satellite litigation. The minute you stipulate qualifications as a matter of law, similarly to stipulating qualifications as a matter of contract, you are inviting people to challenge on the basis that a particular qualification has not been satisfied. The more complex the criteria, the more that litigation lawyers will be licking their lips, because there's so many things you can challenge. What does it mean to be conversant or know about the Indian Constitution? How will that be tested, whether somebody actually knows the Constitution well? What's the level of knowledge that's required? That's something you can litigate on. You can go to court and say that the arbitrator actually didn't qualify as a matter of Indian law because there's one sub-article of the Constitution which we have reason to believe the arbitrator is not entirely familiar with, or perhaps understands it incorrectly. That's an example. I'll give you another example of this, which is from contractual qualifications. There are many arbitration clauses out there in industrial sectors that include specific criteria for arbitrators. One of them, which has been around for many years, which was before the age of equality and political correctness, said that the arbitrator must be a, quote, commercial man. Now, that criteria in an arbitration clause has given rise to a large amount of litigation and challenges. Challenges because people say that the arbitrator is not properly characterized as a commercial man. What does commercial mean? And that is something which doesn't just crop up at the seat of arbitration. This is very important. It's not just a challenge that will be in India. This is a challenge that could be hanging over the arbitration process anywhere around the world where recognition and enforcement is sought. Wherever an award is brought before a court around the world to be recognized and enforced, the way is now clear for somebody to take the 8th schedule and say the arbitrators were not properly qualified as a matter of Indian law, and then slow down the process as a result. So all of that to say that I think this is very, very unwise, and it's not, I think, the most effective way to actually have quality control. If the instrument is actually just too blunt.
Thank you. I'll probably now hand it over to my colleague Bhavna to sort of take up the next questions which are there. Bhavna, over to you.
Thanks, Ashish. So another very important amendment that the 2019 Act brought forth is that on timelines. So as our callers may also know, delay is one of the biggest issues in Indian litigation and arbitration. So the Arbitration and Conciliation Amendment Act 2015 tried to resolve this to some extent by suggesting that arbitrations should be completed within a timeline of 12 months from the date that the arbitral tribunal comes into reference. This could, of course, be extended up to 18 months. The 2019 Act has brought two significant amendments to this timeline. The first is that it states that this 12-month timeline will commence on the date the pleadings, that is, the filing of the statement of claim and the statement of defense, is complete. It also says that parties have to complete the filing of the pleadings, statement of claim and defense, within a period of 6 months. Another important and interesting amendment is that it excludes international commercial arbitration from this 12-month timeline for completion of arbitration proceedings. There is a non-binding proviso which has been provided, which states that there should be an endeavor to complete international commercial arbitration within 12 months, but this again is a non-binding proviso. So first, I'd like to ask Vyapak, what are your thoughts on these changes to the timelines? And then perhaps we can hand over to Toby for an international perspective.
I think this is one classic example, in my view, where we have undone something which was done excellently well. In fact, in my view, this was one thing which we thought while talking to international people that they want to emulate what India has done so far as arbitration is concerned, because delays are no unusual or unique to India, and they are problems in many other jurisdictions about delays. I think uh, somewhere in the process there was little criticism as to what happens after 18 months. You have to go to court. But I think over a period of time since 2015, at least, you know, the practitioners I have met and discussed and our own personal experience, the law on timeline was working pretty much well. If there are few extensions, courts were very, very prompt in granting those extensions, but there was always this uh, constant endeavor to finish it either within 18 months or within one or two extensions thereafter, which brought the big uh, change in the way culture and mindset about arbitrations in India, were practiced. Uh, the problem was possibly a little simpler. That what happens for complex arbitrations, what happens for large arbitrations. I think the problem was simple and the solution was even simpler. I think the committee was formed with a view to promote institutional arbitration. Uh, just one small change could have made the difference in every way. They could have simply said that so far as institutional arbitrations are concerned, institutions can extend the timeline. That's about it. They don't have to slice the cake between ad hoc and institutional. They don't have to slice the cake between domestic and international, and nothing is required to be done. It could have solved many, many problems. People would have been incentivized to go to institutions, at least for international commercial arbitrations, complex arbitrations, large arbitrations. And if you are doing it ad hoc, then it is important that you then follow the process of timeline the way it is. I think this could have solved this problem very easily, rather than complicating in a way where they have completely removed international commercial arbitrations from timelines, even if they are ad hoc. And two, they have now brought a great point of litigation as to when these pleadings are complete in 6 months. If they are not completed, what will happen? What do you mean by pleadings? Whether counterclaim and rejoinders are pleadings or not? What if new issues arise? And so on and so forth. In my view, uh, one thing which was great about 2015 Act was timelines, and we have completely undone what we did in 2015 from an international perspective. But again, we like to hear Toby on this, because I know initially there was a lot of criticism about the timeline, but internationally everyone boasts completing their arbitrations within 18 to 24 months. So what is so great about what has been brought in as part of our law? And if at all you wanted to do it 24 months, it could have been simply said that rather than 12 plus 6, it could have been 18 plus 6. So I think we have, avoided what can be a simple solution by bringing in a lot of complexity to it. But Toby, we would like to hear from you. What is your view on that?
Thank you very much. I entirely agree with everything you said, actually. I think it's right to start by saying there was a lot of skepticism internationally about this provision when it was first introduced. There were major debates about it. There were concerns that it was heavy-handed, that it was too blunt, again, as an instrument, that it was inappropriate for all different types of cases. At the same time, it was recognized that speed is a major concern, or lack of speed is a major concern in international arbitration, in particular in this part of the world. And I think what has been shown in the meantime is that actually it's worked quite well, as far as I understand. The experience has been a positive one. And my own view is that it was a courageous legislative instrument. Actually, it was courageous to do it because it was really meeting a problem head on. And if it's worked well in the meantime, contrary to international fears, then excellent. It should be maintained. And so I think on that basis, it's a shame then to lose it now for international arbitration, when there doesn't really seem to be any particular reason for doing so. On top of that, where I have a major concern now is the detail of how it's actually to operate. And this is the point about it going from the starting point being a closing of pleadings. There are obvious points to make which have already been made, about what does that mean? When are pleadings closed? How does that work in complex cases, etc.? But there's a bigger point which I wish to emphasize. What this provision is doing is it's simply restating a commonly held assumption, which is an incorrect assumption about arbitration. And that is that it must procedurally follow court. There must be a statement of claim, and there must be a statement of defense, and there will be a pleadings phase which will close. And beyond that, the process will then continue very much like it's always continued in an adversarial court setting. And actually, there's nothing as a matter of law that requires that. This is a problem that's infused in arbitration. It has been for years. And what we should be doing is allowing arbitration to be flexible. We should be allowing it to be completely unlike court. It should be tailored to the needs of the particular dispute. So why should there always be a standard pleadings phase, which culminates in a closure of pleadings, which will then trigger the legislative time period? There are many cases now internationally that are being handled very differently, that are being handled on more of an adversarial, an inquisitorial basis, where you don't have one statement of claim and one statement of defense. You will carve it up into different issues which are explored at the initiative of the tribunal. You may have a tribunal calling a meeting for an opening submission, which is way before any full pleadings are made, actually, or partial pleadings, and then follow-up pleadings on different issues. So all of that, I think, is swept away by this time period because it's assuming a particular procedural constraint, which I think is unhelpful, actually.
Yeah, you are right, because what if you want to bifurcate certain pleadings or certain issues, and then you have no option but to finish the full pleadings in 6 months, where you might not even require at a later stage, because a lot of arbitrations get over in the first bifurcation, partial award or something like that. So we entirely agree, and we really think that this was not happening so far as the Indian arbitration is concerned, because this is definitely going to be a big blow for India-seated arbitrations, in my view. But with that skepticism, but with some more positivity in terms of other provisions that have come about in the law, which we will discuss depending upon the time permits. But we would like to also open the floor for few questions in the meantime, if there are, and then move to other amendments and other issues that which we are grappling with the new law.
We will now begin with the question and answer session. Anyone who wishes to ask questions at this time, please press star and 1 on your touchtone telephone. If you wish to remove yourself from the question queue, you may press star and 2. Participants are requested to use handsets while asking questions. Ladies and gentlemen, we will wait for a moment while the question queue assembles.
So maybe while the questions are queuing up, I have a starting question for Toby. Toby, given these changes, and obviously there are certain other changes as well which are positive in nature, what would be your broad advice to parties negotiating the dispute resolution clauses in cross-border transactions involving India?
I'm sorry to say that at the moment I would be advising not to have an arbitration seated in India. That's a rather short, sharp response. But that comes with the background that India has always been seen as a difficult seat internationally for foreign interests who have always been concerned about the overly interventionist approach of the Indian courts, as well as other difficulties with Indian arbitration and the way that it's conducted. Some of those issues have now been resolved, and other issues have been created. And so I think at the moment there's nothing in this new law that really I think will improve international confidence in arbitration seated in India, I'm sorry to say.
I do note that Section 43J, which is now there, it allows government with the sort of involvement of Arbitration Council of India to amend this 8th schedule. So I do hope government uses that power and sort of changes what is currently there. Now, obviously, if there are any questions, we'll probably take them now.
Can I ask a question?
Yes.
Of course.
Sorry. Just on this very very different 43J terminology. There is also an inconsistency with the Section 11 of the Act, which gives the courts the power to appoint arbitrators. Now, Section 11 actually says that if it is an international commercial arbitration between parties of two different nationalities, then the umpire, the chairperson, will be from a neutral nationality. So there are still some conflicts which need to be ironed out, but I'm not completely losing hope that you can't be appointed as an arbitrator, relying on that particular position of law. But my question to you was on a slightly different point. My question to you, Toby, was on the fact you mentioned the silent arbitration sector and how its perception was that of a government-controlled institution by the mere fact that it was housed in their ministerial complex. But isn't that exactly how the Act also started from the City Hall? Yes. So why the two different standards? Why the two different standards of perception for the Act, which has probably always been seen as a very, very independent and a neutral institution, yes, and a different standard for the Thai Arbitration Center, which we are now, of course, importing to the Arbitration Council.
It's all a question of how confidence is built up over time. And I think that for the SIAC, there may well have been concerns early on in its life about its neutrality. But that's all taken in the context of people's confidence in Singapore, in the Singapore government, Singapore courts, which is not replicated for every other country. So I think it's country specific. But also you have to look at the life of the SIAC, which has transformed out of all recognition over the years. And that'll be the product of many elements. But one of those elements may be a perception now of complete independence. So these things change over time. And that's what one has to learn from.
There are no questions.
Okay. So maybe we can continue with the flow of the session. And maybe Bhavna, you wanted to ask a question.
Sure. So, the 2019 Act also introduces a provision on confidentiality. So, it states that our arbitrations shall be confidential and disclosure would be permitted if necessary for implementation and execution of an arbitral award. This is very different from what the committee report had actually suggested, where they had said that an obligation of confidentiality can be incorporated in the form of a provision into the Arbitration Act, but exceptions can be provided, such as whenever it is exceptions such as disclosure, which may be required to protect a legal duty or to protect or enforce a legal right. So we understand that this is in line with a lot of internationally accepted confidentiality provisions. So, how do you think the confidentiality obligation as it stands today through the Amendment Act will impact the arbitrations? And from your experience as well in other jurisdictions, how would such a confidentiality provision play out?
I think, again, this is a very difficult provision. I think it's going to cause all sorts of problems because it is not crafted in line with what is now really best practice for confidentiality provisions. The initial question is, do you want to have confidentiality at all or have it protected in this way? That's a policy question. It's a live debate around the world. There are those who still say that confidentiality is one of the most important aspects of at least commercial arbitration, perhaps not for investor-state arbitration. There are those who say that it's now actually overrated and the confidentiality shouldn't be protected in the same way as it traditionally has been, and perhaps it's more for parties on a case-by-case basis to agree if they want to have confidentiality. But beyond that policy question, there's simply a question of drafting. The exceptions in this provision are too limited. Even one exception, so far as I can see, is far too limited. We know from long practice in many other jurisdictions that there are other situations where you have to have an exception to confidentiality. So you've mentioned already the protection of a legal duty or legal pursuance of a legal right. There are many others. For example, if you've got entities that have a genuine legitimate interest in the arbitration, such as an insurer or a third party who may well have some competing right to have access to information. You also have a slightly nebulous category, which has been relied upon many times in other jurisdictions, of the interests of justice. What happens when you've got, for example, parallel proceedings with one witness who is testifying in both proceedings and giving contradictory evidence in each? Is it possible to say, well, actually, as a matter of due process and fairness, the fact that contrary evidence is being given in one proceeding should be known in the other proceeding? So there are a whole other range of categories. There's no leeway in this drafting for the court to actually rule on that. It seems to be excluded. So I don't see how that will actually work in practice. I think it will give rise to a lot of tension in the system.
Sure. Moving to the next point, and maybe we can take that up as a last, and then we'll end there if there are not other questions. But the ghost of applicability and retrospectivity about laws in India is just not going. Uh, so far as 2015 amendments were concerned, we took almost 3 years to come to some reconciliation there. And Justice Nariman was, eloquent about it in terms of his judgment as to how 2015 amendments would apply in what kind of proceedings, and basically that law was pretty much settled at some point. And the judgment also said that uh, the law should not be changed on this aspect, or at least law should the legislature should consider this before changing it. But they have gone ahead and changed that as well. So now India is, in my view, the most uniquely placed country where there is a law which is still applicable because of the Balco decision in 2012, and there are certain contracts and certain arbitrations which will still apply pre-Balco situations. There is certain arbitrations which will have post-Balco, pre-2015 situation. Then there are arbitrations which are already dealt uh, post 2015, pre Justice Nariman judgment on the applicability of 2015, and then post applicability of Justice Nariman's judgment. And now we have 2019 law which relates back to 2015 and says this is how 2015 amendment should be interpreted. So we have like maybe sixth law applicable on the applicability of arbitration law. And uniquely 2019 Amendment Act is silent on how these provisions will apply so far as the past, current, or new arbitrations are concerned. So I think it can't be more confusing than that so far as the applicability of law is concerned. And again, uh, this is more Indian issue in terms of applicability. But again, we would like to hear your view, Toby, on this as to uh, how does other countries deal with these situations, and amending laws in this kind of manner and fashion, and knee-jerk reactions, or in a way that they are coming every 2 years or every 3 years. How does that affect the foreign sentiment so far as the jurisprudence is concerned, and the process of arbitration is concerned?
Very, very briefly, it undermines confidence even further. The one thing you do not want to have in arbitration is any kind of uncertainty in terms of the governing regime. Any uncertainty opens the door again to challenges and litigation. And the international perspective on this is that this isn't just a question of an Indian court's ruling. You have this complexity. You have to try and untangle it somehow. But that untangling may not happen before an Indian court. Now, if it does happen before an Indian court, that's a problem because there'll be delays, like any court system. There'll be costs, and the process is rendered vulnerable. But the argument may be at the recognition and enforcement stage. So again, some people raise a reservation as to whether or not the appropriate legal regime in India has been applied, depending on what regime applies. And then when you get to recognition and enforcement, whether it's under the New York Convention or not, elsewhere around the world, you'll have an argument from the losing party saying, actually, this arbitration was conducted under the wrong act. There were references to the wrong statutory regime. Look at this complexity in India, and that's a reason why the award can't be enforced or recognized. And then that's going to have to be resolved. And if it's resolved before a foreign court, if it's a common law system in particular, you may well then have to wait for the service filing of expert reports from Indian lawyers who will then give evidence to the court on foreign law. And then maybe you have to have a process of cross-examination of those experts. Again, this is exactly what you don't want in a system which is supposed to be streamlined, leading towards finality. So it's very, very dangerous.
Sure. So, Ashish, you have also written a couple of articles on this point, and now sitting in Singapore. So, any perspective, a bite on this as to how this would span out or would impact arbitrations in India?
So indeed, as has been sort of said earlier, issue around applicability or lack of understanding around how a law would apply is always a grave concern. However, and at this stage, I would not like to go into what would happen to the old cases, because clearly there is a big quandary. So following the judgment in BCCI versus Kochi, a lot of arbitral awards had moved towards execution and were being enforced. And several parties were ordered to deposit security in court to stall this execution process. Now, this law obviously, in a way, could be qualified as a statutory overruling of a judgment of the court, and could then have consequences on all the previous proceedings which were going on which actions were taken to execute the award. So what happens there? How will the court take it? What will happen in those cases? Do we return those assets which have already been sort of transferred to the other party pursuant to execution of a favorable award? These questions would now have to be looked into. But importantly, the applicability of 2019 Act is now something the government has said they will not speak on and have left that completely open. But when you look at the provisions which are there in the 2019 Act, fair few of them are clarificatory in nature, such as the amendment to Section 17 and the amendment to Section 37. So there should not be major issues around applicability of those provisions. With regard to the other provisions, particularly the change in the process for appointment of arbitrators, again, that seems to be prospective, but given the fact that there is an administrative power being done, possibly in ongoing arbitrations, if the issues again arise, we may see courts ruling towards the side that the new law can apply even for appointment process in those arbitrations. But in other areas, how the confidentiality, immunity provisions will play out, there may be a slight degree of confusion. It would have been useful if that had been clarified, but all I can say is more work for us, and so we look forward to it.
Sorry to interrupt, actually one just came up from Amoga Krishnan from Gujarat National Law University.
Thank you. Good morning. My question is, now that the Act is yet, the houses have passed this amendment, but it's yet to be notified. My question is, once it is notified, what is the road forward? How does the Indian community deal with this amendment, and is there any way we can work around this and still promote international arbitration in our country?
So, I don't know whether we should answer or Toby, but definitely this is going to be very tough now. While there were very, very positive developments since 2012 and post 2015, the jurisprudence has also been very, very supportive of arbitration in India. The experience was excellent. With these amendments, doubts are raised, and it will be very difficult to convince people other than see this in practice as to whether these doubts are, somewhat taken care of the way they are implemented. But at least my view is that this is definitely not welcome in that sense, so far as arbitration in India is concerned. And in fact, we had written an article with a title that these are retrograde and regressive, without a question mark or an exclamation. So obviously, our view is very clear, but we again would want Toby to, answer, and also, his views or his advice as to how do we handle this as we go forward.
I'm trying to sort of end this session thinking of something optimistic and positive to say. I'm struggling over this particular act. I think these changes, at least the ones that we've discussed, are serious issues for India. I can't quite see how they will be solved short of a further amending act. Although there may be some court accommodation through litigation over the coming months or years to find a way around. But I think one positive point I would perhaps end with is to say that what one does see here at least is a legislature and a government that is trying to react to real problems, that is actually responding in relatively short succession with amending legislation. If you compare that to other jurisdictions, naming one, for example, England, we don't have the same legislative agility. So we had a new act in 1996, and when that act was passed, finally, it took a long time to get through Parliament. We were told by government, essentially, don't think of coming back and putting arbitration on a legislative timetable for another 40 years, because there won't be time and there won't be a will to touch it again. Compare that to Singapore, which is at the other end of the spectrum, where Singapore will see a problem and then react within sometimes a couple of months to solve it. On that spectrum, India is proving itself to be alive to issues, to be responsive. And so perhaps my departing thought is to say that whilst that attention is there of people in government, hopefully they can be steered to actually correct this in a short period of time, since obviously they have a live interest in ensuring the future of Indian arbitration.
Yeah. So Ashish, you may want to conclude.
Yeah. So with that, probably we'll bring this webinar to an end. I think we are perfectly on time. That is 1 hour that we targeted. Toby, thank you so much for taking your time out today and coming to our office. We do know that you have subsequent commitments which you need to get to. So with that, I'll thank you once again, and thank you Vyapak and Bhavna sort of joining in from there. And finally, thank you to all the participants who joined in and took time out in their busy schedule to sort of participate in this webinar and to hear the views of the speakers over here. Thank you all, and with that, I'll probably end this webinar here.
Thanks, Ashish, and thanks Mozam and Ria for taking care of our Delhi part of it. I hope Toby is taken care of well, and thanks again for joining everyone. Thank you.
Thank you.